right. Order, please. Order, please. It's now. It's not on. It's now approximately.
It's about 1 minute delay. That's one.
It's about 9:30 a.m. I want to start by refreshing the names of those who are on the phone. I have on the phone, according to my list, Robert Bird. Mr. Bird? Mr. Campion?
Yes.
Is Mr. Gold on the line? Mr. Hartman? Ms. Hartman? Mr. Hunter?
Here.
Mr. Lerner? Mr. Maines?
Here.
Ms. Richardson?
Present.
Mr. Rabinovich?
Here.
Mr. Aaron? Do we have anyone else on the line?
Hello.
Who is that, please?
Bob Aaron is here.
Thank you. Now, would everyone on the line please *6 while I introduce everyone to convocation? Thank you.
Treasurer, it's Ron Maines. I don't know if you got me.
Yes, thank you, Mr. Maines.
Did you get Bob Aaron?
Yes, I did. Thank you, Mr. Aaron. I'd like to welcome everyone to these proceedings of convocation. I want to say that as of 5 p.m. yesterday, we had drawn more than 4,000 visitors to the Articling Task Force debate site, and more than 600 individuals have subscribed to our reminder service so that they will receive a prompt about the debate today. The Law Society is simultaneously hosting an online discussion on the Articling Task Force report featuring journalists, lawyers, and members of the public. Those following the debate can join the discussion online at the following website address: http://live.lawsocietygazette, all one word, .ca, or on Twitter by using the Twitter hashtag articling. Viewers can also comment by email at articlingdiscussion, all one word, at lsuc.om.ca. Again, for those who are on the phone, please, would you *6 so that you mute the line while, if you are not speaking. Thank you.
Treasurer, this is Roger Uchetti. I don't think I registered earlier.
Okay, thank you, Mr. Uchetti.
Thank you, sir.
Several lawyers and legal commentators will also be joining us behind the scenes to provide their opinions and expertise as part of the discussion panel. These individuals are Lee Akasaki, whose Twitter address is @Lee Akasaki, all one word. Mr. Akasaki is a lawyer and a former president of the Ontario Bar Association, and he blogs at his website leeakasaki, all one word.com. Mr. Doug Ferguson, who has a Twitter account @Doug Ferguson 9, all one word. Mr. Ferguson is a lawyer and a professor at the University of Western Ontario and a director of the Community Legal Services in London. Could people on the phone please *6, please? Omar Ha Redeye, who can be found at @Omar Ha Redeye, all one word, is a lawyer, a candidate in the LLM program, and a social media and Canadian legal issues enthusiast. And he blogs at omarharedeye.com and is a regular contributor to the SLAW blog. Jasmika can be found at JKAL, She is a lawyer, University of Windsor law professor, and co-author of the legal text on class action law. Mitch Kowalski, whose address is @M.E. Kowalski. Mitch Kowalski is a lawyer, the founder of Law Tech Camp, and the author of the recent book, Avoiding Extinction, Reimagining Legal Services for the 21st Century. And he is a regular contributor for the Legal Post. Catherine McKenna, whose Twitter address is @CathMcKenna, CathMcKenna. Ms. McKenna is a lawyer and the co-founder and executive director of Canadian Lawyers Abroad, and the author of several articles about articling. Antonin Pribetic, whose address is @APRIBETIC, is a lawyer, and he blogs at the following website address, ATTHETRIAL warrior.com. And Gary Wise, whose Twitter address is @WiseLaw, all one word. Mr. Wise is a lawyer and a blogger for on his blog, Wise Law Blog. Ladies and gentlemen, this is an important occasion and an historic occasion for the Law Society of Upper Canada. It is an historic occasion because for the first time in its 215-year history, the proceedings of the Law Society's convocation will be broadcast over the medium of the World Wide Web. Never in its 215-year history have so many people had the opportunity to watch the Law Society's governing board in action and to participate in the debate that we will be having today. It is an important occasion also because Convocation begins its debate on the recommendations of the Articling Task Force in its report to Convocation entitled Pathways to the Profession, a Roadmap for Reform of Ontario's Lawyer Licensing Process. Many in the profession have told me over the past several months and days that the debate we are about to begin today is one of the most important debates of our generation. The views of the profession and of the public have been engaged and have been galvanized by the issues raised in the Pathways report. Today, Convocation begins its debate of these difficult issues with an unprecedented and direct participation of lawyers, commentators, and the public through the medium of social networking. Ladies and gentlemen, if I can put a new twist on the old saying from the Pogo comic strip, I have seen the future, and it is us. I thought long and hard about something profound that I might say on this historic and important occasion, but the only thing I could come up with was, hello Canada and hockey fans in the United States. So I would like to thank all of the panelists for taking the time today to follow the debate. Et je vous remercie aussi tous les individus qui nous joignent par web aujourd'hui, and I'm very much looking forward to an interesting debate. I would like to call on Mr. Anand to present the motion set out in the Pathways report. I should advise Convocation that Ms. McLean informed me of her intention to make a motion on the floor following the introduction of the motion by Mr. Rajanand, and I have told her I will recognize her following Mr. Anand's presentation. Mr. Anand?
Thank you, Treasurer. Colleagues, the motion is at paragraph 1 of the report, page 6 of the report, page 7, I think, on board books. That Convocation approved the following pilot project respecting the transitional training component of the Law Society's licensing process, the integrated components of which are as follows and the details of which are set out in this report. Now, I'm not going to read the 2.5-page motion that follows. I will summarize it very briefly in English and en français. The majority of the task force recommends the Convocation approve a pilot project that will allow articling and a new law practice program, LPP, to operate side by side for 5 years. While articling would continue to be the route through which most candidates become licensed, the LPP, which would include both a skills training program and a cooperative work placement, would provide an alternative path to licensing. La majorité des membres du groupe de travail recommande que le Conseil approuve un projet pilote qui permettra au programme de stage et à un nouveau programme de pratique de droit, PPD, de fonctionner en parallèle pendant 5 ans. Le stage continuerait d'être le chemin par lequel la plupart des candidats obtiennent leur permis, mais le PPD, qui comprendrait à la fois un programme de formation de compétences et un stage coopératif, fournirait une solution de rechange. So the motion at paragraph 1 is moved by me and seconded by Mr. Mercer.
Thank you, Mr. Anand. Ms. McLean?
Thank you, Treasurer, and thank you for giving me time to bring forward this motion. Treasurer and Ventures, you have all received in the last few days many emails from various stakeholders, including the Advocate Society, the Criminal Lawyers Association, and the Windsor Law School Dean, and the students, expressing concern about the very short period of time between the public release of the final report of the Law Society Articling Task Force Committee and today's debate. It was released October the 15th. There is no doubt that this report is crucial and historic, as you've indicated, Mr. Treasurer, and it's most important to the profession and the public. There is also no doubt that the report reflects the extraordinary work undertaken by the committee and the Law Society staff, who should be recognized and thanked for the countless hours of meetings, deliberations, and dedication to bring forward this report. But 10 days does not permit the stakeholders enough time to fully appreciate the report. Mr. Treasurer, I would like to move a motion on this, that the motion that is before you, brought by Mr. Anand, be deferred for debate and for voting to a date to be fixed by you in the future. This motion is seconded by Ms. Blackhouse. Thank you.
Thank you. Anyone wish to speak to the... Okay, Ms. Murchie?
Thank you, Treasurer. I'm standing to oppose this adjournment and to encourage Convocation to proceed with this very important discussion on the proposed change that is before you now. As you know, the context in which this articling debate and discussion and consultation has occurred is within the regulatory concern to, number one, provide fair access to the licensing process for the candidates for licensing. And I think we all know that increasingly there have been an insufficient number of placements. By March of this year, the number of unplaced candidates was at 15%. At the same time, the regulatory context requires us to maintain or strengthen the entry-level competence within the profession. And in my submissions, the debate should proceed for 2 reasons. The first is that there's been extensive consultation with the profession already. In terms of that consultation, it started in December of 2011 when the Articling Task Force presented its consultation report to the profession and to Convocation. there were 5 options that were established in that report for potential transitional training programs to address or otherwise the issues that are concerned, but for discussion with the profession in the context of the regulatory issues I've outlined. Those 5 options were the status quo, which we have now, articling. That was number 1. Number 2 was articling with some quality assurance improvements. Number 3 was to abolish articling and replace it with a limited post-licensing requirement. Number 4 was the option that is before you today and was described by Mr. Anand in the motion. It is the option that provides alternative pathways to licensing, including articling and an LPP program consisting of practical training plus a co-op, and it envisages as well an ultimate assessment. And the 5th option was the LPP alone. Now, by the end of March 2012, the Articling Task Force had held 25 consultation sessions with the profession in communities across the province, with deans, with students, with law schools as well. And we've received 125 written submissions, 70 of them from lawyers or law firms, and 55 from various organizations. And in the context of that consultation, the Articling Task Force has had input on every single option. The pros and cons of each and every option were weighed and considered, and those who participated in the process gave us their views on the pros and cons of all of the options. There was, I should say, varied support for the various options. There was some support for all of the options. And there were concerns expressed about all of the options. We heard from those who said, leave articling alone. It's worked for a lot of years, and it's the best we have. At one end of the spectrum, to those on the other end of the spectrum who said, it's outdated and it's outlived its usefulness, it's time to move on. And to a person and an organization, all of those responses and all of that input was thoughtful and reasoned. And it was very helpful to us in coming to the recommendation that we're making for you today. In fact, it was instrumental in assisting us in making this recommendation. It allowed us to consider and weigh the advantages and disadvantages of each option in the context of achieving the goals that I described to you earlier. Now, the majority of the task force has recommended option 4, the dual pathway, and we've had significant input from the profession on the merits and the shortcomings of option 4 already. We've heard from literally thousands of people through the consultations and through the reports that have been filed. And the summaries of those consultations are available on the website, the Law Society website, and have been since May of 2011. So we've had input on the option that we're recommending today and on all of the other options, and that's the basis on which, in conjunction with the other information we've gathered, we're making this recommendation to you today. Which brings me to my second point, which is really the most important one, is that the benchers have the information, you benchers have information that you need to debate and decide this motion today on a principled basis. Now, in the context of the goal being to have a licensing system that provides fair access for candidates and develops the skills required for entry-level competency, the information before you is the December 2011 report that I indicated to you before, that sets out the 5 options for transitional training. You have the interim report of the task force in May 2012. You have the summaries of the input from the profession that are posted on the website, And those summaries provide input on every single option. And I think it's fair to say that all of you, and certainly if not all of you, most of you, have been at least at one information session with the profession. I know the Articling Task Force has heard in person from a lot of people, and most of you have been in at least one of those sessions so that you can hear from your colleagues as well. You've also attended venture information sessions where the Articling Task Force has kept you up to date, and you've had an opportunity to learn about and review the final report. So this is not a matter where the whether the recommended option is popular with the profession. And certainly a deferment would allow us to hear from people who don't like what's being recommended or who do like what's being recommended. But I can tell you already that this will not be popular with everyone. It's as simple as that. We already know that. Some people strongly oppose any change. Some, and they want to leave articling as it is. Some, on the other end of the spectrum, favor abolishing articling, and there are many positions in between. And it's my view, and I urge you to really consider this seriously, that it's our responsibility to decide whether the majority recommendation best meets our goals of fair access and of entry-level competency, not whether it's the most popular option that is available and ought to be talked about. This provides a fair and principled basis for us to make a decision, having consulted the profession extensively. And we're here today to talk about it. The Articling Task Force is here to talk about it and to answer any questions or concerns. This is where the debate should occur, right here with all of the issues being put on the table, issues that your colleagues from across the profession have told us about already, their concerns, their views, and their perspectives. So I urge you to really consider seriously and to vote against an adjournment, because you have the information you need, and a further consultation will really not assist in the debate or in the decision, in making that decision on a principled basis. Those are, that's my comments, Treasurer.
Thank you, Ms. Murchie. Next on the list I have Ms. McGrath.
Thank you, Treasurer. Unlike Ms. Murchie, I was not on the Articling Task Force, but I've certainly read the reports. The consultations have been extensive over the dealing with all 5 options over a period of 18 months. And one of those 5 options that was put out in the December 11th report is now before us as the majority recommendation. There's no variation to option number 4. It's option number 4 as set out in the December 11th report, and there's been extensive consultation on that. As Ms. Murchie said, we've received many submissions, had many consultations with the profession around the province. We certainly have the support of the OBA, CADELPA, and the Toronto Lawyers Association to proceed to a decision now, because they have taken the position that we have done the extensive consultation necessary to support the debate and the decision being made. We need to deal with the questions, and we need to come to a decision. This is our decision to make. We have to have the courage to do it, and to do it sooner rather than later. So I urge you to defeat this motion to defer and proceed to the debate on the merits.
Thank you, Ms. McGrath. Before I call on the next speaker, I see that Max Rubin on Twitter is saying, side note on the articling debate, there are a lot of iPhones and iPads in the room. Silent mode, perhaps? So people are having difficulty hearing the debate because there's too much noise, for example, on the conference call. So again, those who are attending convocation by conference call, please now *6 to mute, so that we can have, so that we can get make sure that those that are following the debate on the web can actually hear what is being discussed. Thank you.
Mr. Director, would you please add me to the speaker list?
And who is that?
Mr. Lerner?
Thank you, Mr. Lerner. And now, Mr. Lerner, could you *6 while we wait for you to be called? Thank you.
Thank you.
Mr. Wardle?
*6.
Takes the gravitas of Mr. Porter to get anybody to do anything.
Way to go. Way to go.
Thank you. Mr. Wardle?
Treasurer, colleagues, members of the profession, and importantly, licensing candidates who are watching this debate, I rise to support the motion to defer. When we wrote the minority report on articling in August, we did so out of deep conviction and hope. And the hope was that this would spark a real debate within our profession about the future of the licensing process. A debate based on two principles: how can we best ensure competence, and how can we best ensure that our licensing process is fair. We now have the profession engaged in that debate, but that engagement started in the last 4 days. And with respect to Ms. Murchie, this is not the same as the consultation process. The consultation process that took place last winter, and I was a part of it, involved 5 options that were put out to various stakeholders and the profession as a whole. And everyone was asked, what do you think about the 5 options? Send us your thoughts, send us your comments, and we'll think about them. We now have 2 well-reasoned, carefully considered reports. They deal with the largest change to our licensing process in the last 50 years. The profession wants to be part of the debate. 10 days is not enough with respect. You know the concerns that many of us in this room, particularly those of us that wrote the minority report, have about equity issues and the effect that going forward with these changes might have on equality-seeking groups. And I want to point out that among the submissions we've received over the last few days in favor of a deferment was one from the Canadian Association of Black Lawyers, and I want to quote from that letter, which said, "We wish to impress upon benchers the importance of a process which allows for a reasonable opportunity for a reaction to the final report and a proper process for input by the profession before a vote is taken." There is no urgency that requires us to deal with this motion today. The majority report proposal proposes a pilot project that will not start until 2014. There is no need to decide this month or next month. The profession needs time to absorb, to reflect, and indeed to consult with us. This is an opportunity for us as a group to rise above petty politics and deal with matters of principle. It's not about winning, it's about process. And we have to allow time for the profession to absorb, to reflect, and to provide feedback. And that feedback will be good for this organization. Too many times this organization is accused of being out of touch with the profession as a whole. Now we have their attention. Now we have our attention, and when we have their attention, we're proposing to simply say, that's enough. We actually don't want to listen. We're going to go ahead with this debate today. How can we close off the discussion now that we're at this point? So, in my view, the motion proposed by Ms. McLean demonstrates that we are responsible, that we are open, and that we are listening with an open mind to all participants in the profession, including those going through the licensing candidature process. And I want to close by just reading from an email I got this morning at 8:25 from a new lawyer. Dear Benchers, I am writing to request that you vote to defer voting on the recent Articling Task Force report. As a 2011 call, I am very interested in and concerned with the process by which young lawyers are trained and qualified in Ontario, but I do not think that my colleagues and I have had a sufficient opportunity to read and react to the task force's report. It is 100 pages long, was only released on October 15th, and the vote is scheduled for today. And then he goes on to say, I know that a number of us would very much like to have an opportunity to provide you, the governing members of our profession, with our comments on the majority and minority positions set out in the report. I therefore ask you to defer the vote and allow a greater opportunity for feedback from the profession. Who can quarrel with that logic? Who in this room can quarrel with that common sense? Thank you.
Thank you, Mr. Wardle. Mr. McDowell.
Treasurer, it's John Campion. Could you add me to the list, please?
I will. Thank you, Mr. Campion.
Thank you.
Treasurer, I rise to speak against the motion to defer, as I confess that this position has caused me to lose sleep. First of all, I believe that we do owe the profession a selective mea culpa. In a perfect world, we would have released the reports earlier. We would have devoted more resources to publicity about our timeline beginning in the late summer, and we would have consulted about the preferred option much earlier. Because it's one thing to say, well, we've got a list of options, and what do you think of our options? It's another thing to say, here's our option in great detail. And so I think we all share responsibility for that. We should have had this level of engagement with the profession a month or more ago. Now, over the past few days, I've heard from close to 100 groups and individuals, and as solicited, the tide is running about 95-5 in these pieces of correspondence in favor of deferring the issue, the notable exception being from a Mr. Sullivan of Hamilton. And I have to acknowledge that the letters have come on both sides of the deferral issue from a broad sweep of the profession. It's not just the Advocate Society, but some of the leading members of our profession, as well as first-year lawyers and even individual law students, the Criminal Lawyers Association. Other groups have weighed in on the other side of the issue. In my way of thinking, we should proceed today to begin the debate. Frankly, I am skeptical that the debate will conclude today in any scenario. The first time I sat in this room, Treasurer, you said that we had to have an adult conversation about articling. I wasn't so sure about the turn of phrase. It was a bit Dr. Phil for me. But taking a hard look at the options in the articling process and developing new options to supplement, to revise, or replace it, consumed enormous energy and resources in the term of Treasurer Politza and in your term. I think it is fair to say that no one can criticize fairly the steps that were taken to consult about the options. There was consultation from one end of the province to the other with the law schools, with the Federation, and so on. I see this debate as approval for the direction which we are being asked to take in articling. And the adult conversation does not end in our vote on the question of direction. I happen to believe that the two-stream direction is the correct one. But as we go forward in implementation, there will be extensive consultation because, frankly, we are feeling our way. There will be stringent monitoring of the alternate stream. We will call on our service providers to give us reliable assurances about placements. We will engage with the profession throughout. We will monitor, really for the first time, the effectiveness in a pedagogical sense of articling. We will monitor the outcomes of licensees who have come through the alternate stream year over year. If the results for the alternate stream licensees are as dire as Dean Mayo Moran, for whom I've got enormous respect, predicts in today's Toronto Star, then we will have to have a hard look sooner rather than later at the hybrid model which we will have created, if that is the will of Convocation. But at the end of it, we were elected to govern. You're elected to think about this issue and get on with the debate. Whether we arrive at the destination or not today, it's my own view that we have to embark. Thank you very much, Rick.
Thank you, Mr. McDowell. Ms. Potter?
Thank you, Treasurer, and to fellow benchers and those who are tuned in. I support the motion to defer the decision that we are being asked to make today. And I take to heart the comments that have gone before me. Certainly Ms. Murchie, as part of the task force, spent time and energy, and all of the individuals involved in that task force certainly have been commended by the benchers for their efforts and their passion and their belief in the importance of the work that they are doing. We believe that, and it is important work. We've heard that it is the most major change that we will institute in many, many, many years at this particular law society. I remember a colleague of mine, or actually a mentor colleague of mine, telling me one time, a long time ago, that aside from personal issues, there is nothing that can't wait for 24 hours minimum. I've never forgotten that. We've heard from people outside the Law Society, and we've heard from people within the Law Society, that some delay will not rock the boat in any way, shape, or form. That if we err, we should be erring on the side of caution. We should be getting the input that people want to give us with respect to the proposals that have now been finalized from all of the materials that have come in from the stakeholders. It's true that this is a complex issue. It is not an easy thing to resolve. We certainly will never please everyone. But having said that, I have some concerns about a program that would, I don't really want to get into the merits of the program or the options put forward. So let me just suffice to say that if we can delay this decision for another short while to accommodate those who wish to provide input on the options, my bet is we will come up with a better vehicle. It may be similar to what's out there on the table today, but it will be, hopefully, have some additions and suggestions that may make it a more scalable and a more hopeful option. And I see no harm whatever, none, in delaying, other than possibly an impression that we have not got confidence in the people that have come forward with the program or the options that we see before us today as a result of extremely diligent, hard work. That isn't the case, and I hope no egos would be bruised in allowing us the opportunity for the input that people are seeking and wish to provide. It's like advertising. Nobody pays attention to it until it relates to you. And there are people out there that haven't paid attention to articling until suddenly they're in the market and now they're looking at it and they want to be able to respond. We owe them that. We are the governors of this profession. I urge you, You have nothing to lose in delaying this for a short period of time in the hopes of getting it better. Thank you.
Thank you, Ms. Potter. Mr. Evans?
Thank you, Treasurer. I just have a brief comment. I was speaking to Morris Joshua yesterday. He's the president of the Ontario Bar Association, and it's his position on behalf of the association that we should proceed with the decision today, with the debate, and he's also in favor of the majority report. And I wanted to bring that information to your attention. That is also my position.
Thank you, Mr. Evans.
Point of clarification.
Yes, Ms. Boyd?
Is the motion to defer the debate or to defer the decision? I can't recall. I've heard debate, decision. What is the actual motion on the table?
Thank you, Ms. Boyd. The motion is to defer the motion that was introduced by Mr. Anand to a date to be determined by the Treasurer.
Thank you.
Mr. Faulkner?
Mr. Treasurer, colleagues, there's no doubt that we as Convocation are hardly a symbol of perfection. I thought that my colleague, Mr. McDowell's mea culpa was a very fair one. I routinely hear about our failure to be sensitive to what's going on the ground. I routinely receive digs about my access to food and other lovely perks. And I say this to my colleagues and to you, Mr. Treasurer, if I thought adjourning this debate today would somehow create a better vehicle for us to make a decision, then as a matter of conscience, I would support a deferral of the debate. What I truly believe this is about is our understanding that there are those who missed out because, frankly, as lawyers, we are the consummate example of chasing our tails at the last minute. This is an adjournment application, if you will, by the profession. And it's because people didn't read the notices in the ORs. They're human. They don't follow the goings-ons of the Law Society and the consultation announcements. They're human. They have day-to-day activities and lives and jobs. And now as they wake up, and in fairness to them, they are waking up as a group, they realize the import of the work done by this very special task force. Now, I very carefully identified the word adjournment of debate. I say this. I propose a friendly amendment. I propose adjourning the decision. I propose that the debate go forward today, that we have the courage, having been armed with a plethora of information, to have the debate. But what I say is the decision itself should be with the benefit of the input of those who may well suffer from latches. That is, like the rest of us, they may well be in the position of having to be candid and doing the same kind of mea culpa Mr. McDowell did. This isn't an issue about being technically right or wrong or whether people were on time. They want to have input. Let them have that input. I propose, in essence, cutting the loaf in half. We have the debate today, a strong debate. But I propose that we hold off with the decision so benchers can vote when they have also received input. Now, for those who would say that I'm trying to ride both horses, I say this. We have to adjust to input. I want to close by saying this. Even if both debate and decision happen today, I am satisfied that this is not just about understanding about fair access. It's about understanding about overcoming barriers. And that we're in a position to address, we're in a strong position to address those barriers today. But I urge us to consider adjourning the decision itself and allow people to have input once they've heard us on the debate.
Thank you, Mr. Faulkner. Mr. Lerner?
Do we have to consider that?
Thank you, Treasurer.
Excuse me, Mr. Lerner, if you wouldn't mind, there's no, Mr. Faulkner, there's no motion.
I'm sorry?
Mr. Faulkner, you have not made a motion. You've commented on the motion that's been brought by.
Mr. Treasurer, I apologize for my technical failures. It's all part of the human reality. I bring a motion at this stage to adjourn the decision, to have the debate today, to allow the entire profession to access the debate, but to adjourn the decision to a point that you identify as reasonable for us to get input from the rest of the profession, but to have the debate today.
If I could just have a moment, Mr.
And Mr. Treasurer, I want to make clear that the motion is not...
Mr. Faulkner, do I understand that you are moving to amend the motion that's been brought?
That's correct. And
Could people on the phone please star 6 again? We're getting a lot of feedback. Somebody's in transit someplace. Mr. Lerner, could you star 6? Mr. Porter, could you tell Mr. Lerner to star 6? Thank you.
And I want to make clear in terms of the spirit of the motion, it would not foreclose continuing the debate. I say the debate starts today. I say the decision be deferred. It would not foreclose continuing the debate, if so advised, Mr. Treasurer. But what would be important is the process commences today.
Right.
And that all I am truly seeking is an assurance that those who seek to continue to have input, regardless of all the laches arguments in the world, should have the input, but we should start the process today.
Fair enough. So, as I understand your motion is to amend the motion that's on the floor to defer the decision on the pathways report.
I bring it as a freestanding motion because I do not seek to simply as a friendly amendment to Ms. McLean's motion. I bring it as a freestanding motion to ensure that it's dealt with on its merits.
Okay, so first of all, do you have a seconder for your motion?
Could I have a seconder?
I'll second.
Ms. Leeper is seconding the motion. If I could just have a moment. Mr. Faulkner, Ms. McLean has informed the Secretary of Convocation that she considers your motion to be a friendly motion to hers.
A friendly amendment.
Friendly amendment, sorry. Excuse me, friendly.
Yes.
Well, Ms. McLean, you haven't been recognized.
Yeah.
Fair enough, and I would propose it as such.
As a friendly amendment to Ms. McLean's motion, and Ms. McLean accepts. Ms. McLean, you accept that as a friendly amendment?
Well, perhaps,
Mr. Treasurer, the good news is people are actually seeing how convocation works.
Mr. Treasurer, Mr. Faulkner's amendment, if it's to start the debate but not finish the debate, I don't have any problem with that, as long as the debate continues at another date. But I don't want, that's what he said. First of all, we want to finish debate.
I think
That's the distinction.
And Ms. McLean raises a good point, and in answer to a question, the answer is yes. And as a result, it is a friendly amendment.
Yes. Contrary to some of the opinions I'm getting, it's a friendly amendment.
Okay, now, I'm just going to have the Secretary read what we understand to be the amendment.
That the decision but not the debate on the motion at paragraph 1 of the report be deferred to a date to be determined by the Treasurer.
Could you repeat that again, please?
That the decision but not the debate on the motion at paragraph 1 of the report be deferred to a date to be determined by the Treasurer.
No, the debate would continue.
All right, yes. Is that acceptable, Ms. McLean?
Yes.
Yes. So that is the motion that is currently on the floor. That's the motion that we are now debating. It is Ms. McLean's motion as amended by a motion for a friendly amendment made by Mr. Faulkner, seconded by Ms. Leeper. All right? Okay, I still have a list, and we're going to continue with this list. So, Mr. Lerner, you now have the floor. Mr. Lerner, star 6.
First of all, I'd like to apologize for the problems in muting. I'm having a difficult time driving while I'm texting and drinking my coffee, and that's the problem. It is regrettable that we are engaged in a discussion on process and not dealing with the substantive issues. And I don't want us to, while we discuss this process, to forget the importance of the issue that is really before us today. There are a number of comments that I've heard today that are entirely with merit, and they make sense. But ours is a profession that has always treasured and respected the ability of everyone to be heard. And while I initially thought that the debate ought to proceed today, I am persuaded by Ms. McLean's motion as amended by Mr. Faulkner that the matter proceed as has been suggested. I am concerned with one aspect of the motion, and that is to a date to be determined by the treasurer. Not because I have any disrespect or lack of confidence in the treasurer, but I think those who are participating in the debate today need to know with certainty when we are going to come back and deal with the issue. There has been a great consultation process with a number of person consultations and submissions submitted to the task force. I suspect that the participation of the profession and the organizations and those who are interested in the ultimate decision have had an opportunity to be heard, but they have not had a full opportunity to comment on the proposals that come forward. My view is that I support the majority proposal, but I would be troubled if after the decision is made, which I have no doubt will not be universally accepted, one of the criticisms of the bench is that we did not allow due process to take its course, and we did not allow those who wished to be heard to speak. So, on the basis of what I have heard, I support the amended motion. I do ask that we fix a date today when the debate will be concluded, and the time frame that I am thinking of is something within the next 30, no more than 45 days, so that prior to the conclusion of this calendar year, we can move forward with whatever decision has been endorsed by the majority of Convocation. Thank you, Treasurer. Those are my comments.
Thank you.
Star 6!
Mr. Mercer, could you star 6, please? Thank you.
Treasurer, Convocation, I rise to oppose the motion on the following basis. In my view, we've had a long and an effective consultation. The views of the profession are in fact well known on the alternatives before us. We've heard in the last days from the Advocate Society, Cadelpa, Toronto Lawyers Association, OBA, Cable. The truth is that we know we have a difficult decision and that there are imperfect alternatives. We know that the choice will be difficult, and we know that the choice won't be any clearer than it actually is today. If we thought that we would have a materially better result, a materially better appreciation of the right choice, then there would be logic to a short deferral. There is, of course, probably no great harm to a short deferral, but the truth is we will not be better off in the decision-making, which is our responsibility in the end. I want to make the point that this isn't just abstract. This isn't just about the question of the last person finally getting to read the document and saying what they have to say. Mitch Kowalski, one of the commentators today in his tweets, made the point that anyone who is serious about reading the report and coming to a view will have done so and will have been able to comment. I think that's the truth of it. I think their perspectives are known. But where are we now for real people? For real people, the most recent information is that we've got about 400 people in the current year who are unplaced. 13% of the Ontario candidates, Ontario grads, are unplaced. 23% from other Canadian law schools, 29% from Canadians trained overseas, 52% of foreign-trained candidates from Australia, England, and the United States, and 75% of foreign-trained candidates in other countries are currently unplaced. 1 in 8 of the candidates from last year from foreign countries, foreign-born, are not yet licensed. It is true that those numbers will not change substantially if we decide next month or in December. But the truth is there is a pressing problem for real people to address. The majority and the minority both care about that. We have different ways to help, different ways to address that unfairness. But in my submission, we know what the alternatives are. We have the basis to choose between them, and we should get on with our job.
Thank you, Mr. Mercer. Mr. Campion?
Thank you, Mr. Treasurer. Mr. Treasurer, I, for one, support the notion that we are elected to decide, and decide we should and indeed will. I have had the benefit of hearing the report early and talking with our colleagues as to the complexities, and raised a host of issues myself on the report and had very good answers, indeed on all sides. As I see it, the issues not only deal with what Mr. Mercer has to say, and that is the concerns that we have about people who are coming out of law schools and cannot be licensed because of a lack of articling positions. It also deals with the history of articling, connected as it is to the great debate about whether training or academics is the way to proceed, and articling was the compromise. There are great market forces at work that we are engaging. One is, of course, the law schools themselves and their expansion. The expectation, or not, of students to be able to be licensed to practice once they've gone to law school. We have an impact on the profession, and most important of all, I think, the protection of the public, all of which I think everybody understands. And finally, I wish to raise the notion that we will have an impact on other provinces and the mobility that the Federation has taken so long to put in place. Because if whatever system we adopt here is not accepted elsewhere, it could, I suppose, cause others to be concerned about the candidates who are coming from this province or otherwise. What impressed me, as much as I think that we should continue with the debate now that the profession is engaged, is that the number of people and the quality of the people who have said they haven't had enough time. We, as the committee, in its incredible amount of work, actually put consultation at the top of its list, or close to the top of its list, of things to do. And in my view, because we have a split report, and a very important minority report under consideration, because there has been little time for everybody to really focus on the solution we might adopt, I am of the view that we are going to receive broad acceptance, not only from the profession, but also from the public at large. We should hear from those people in a timely way as to what their views are on the proposed solution, so that they have an opportunity to, one, have an input and therefore accept when we do decide what we're going to do. So with some reluctance, I will say, but having regard to the quality of the concerns raised in the last few days and the number of concerns raised in the last few days, I see this as a great opportunity. One, to have the debate today, and two, to continue the debate after we've heard any further input, and those who wish to have input may be indeed persuaded by our debate. So I believe that the solution put forward in the motion by Ms. McLean as amended is one that we should adopt, and I'm much obliged.
Thank you, Mr. Campion. I still have a fairly lengthy speakers list here. I'm going to ask those speakers who are coming next to try to encapsulate your new thoughts as quickly as possible, because at some point we have to vote on this. So I'm going to now call on Mr. Sullivan.
Thank you, Treasurer, Ventures, members of the profession. I'm not a mea culpa person on this. The Law Society's done an extensive review of this. That began with the Articling Task Force. There's been multiple submissions. I think we've done an excellent job of consultation with the profession, with the various groups. These options have been on the table since 2011, December, when we published the report. We've debated vigorously with the minority group, with great civility, I might add, great respect for each other's views. We've crisscrossed the province. Now's the time to make the decision. The main point I want to make, the Law Society has done an outstanding job of consulting.
Thank you, Mr. Sullivan. Mr. McKenzie?
Thank you, Treasurer. My points have largely been made by...
If you could go to the speaker.
Sure. I don't usually like to come to the podium because, in my experience, people who come to the podium take longer than people who speak from their seats. I'm following the Treasurer's direction on that. When I put my hand up, it was to support Ms. McLean's original motion for reasons that have been well expressed by others. 10 days isn't enough. I may well feel differently about it if it weren't for the fact that this debate is both so important and so difficult. The difficulty being evidenced perhaps most graphically by the dissent of the 4 members of the task force that have put this put their report forward. Obviously, the consultation process that the task force engaged in was exceedingly thorough, and they're to be commended for that. But I do think it's different to come up with a very detailed majority proposal and a focused minority proposal, rather than having 5 generalized options for discussion. And I think there are a couple of possibilities if we do defer a decision here that might benefit the profession at large and the public. One is that there may be more of a consensus that grows if we give everybody a few more weeks in favor of either the majority report or the minority report, or importantly, either some third alternative or some variation on either the majority report or the minority report. I've read both of them with interest. My own view is that both of the proposals could conceivably be improved, and I, for one, would like to have the benefit of the views of stakeholders and other members of the profession before voting on this issue. Now, I said that I originally rose to support Ms. McLean's original motion. The compromise that has evolved from first Mr. McDowell's speech and secondly from Mr. Faulkner's motion is one that perhaps appeals to me in retrospect even more, because it will give us the benefit of debating the issue to some extent today. That will inform the views of others who are interested in this and who wish to make their views known. And the only other thing I'd like to say is that I never thought I would use the words McDowell, Faulkner, and compromise in the same sentence.
Point of clarification, Treasurer. What do you propose you propose November or December as if this motion is carried?
Well, having discussed that very question with a number of people, including Mr. Griffin of the Advocacy Society, my inclination was if we could continue the debate in November. We have the budget as well in November, which also may engender some debate. That would be my proposed date. That will give the profession well over 40 days to comment and to provide input, and it will also permit further discussion of the recommendations. It will mean a long day for us in November, but that was the date that I had in mind.
And is that the motion now?
Well, the motion now is to a date to be fixed by the treasurer. So and if that's the motion that passes, I will fix November convocation date for continuation of the.
Thank you very much.
I think we're ready for the question.
Well, there's a fairly long list, and this is I am trying to keep in mind here that many lawyers in various law associations have urged us to make a decision today, and others have urged us to defer the matter. And that's why this question, we may not like the procedural wrangling, but in fairness to the profession and the various organizations in the profession, we have to have this discussion, and Convocation, which is the body charged with making these decisions, has to decide whether it wants to proceed today or consider further submissions from the profession. And so, while it is a tedious discussion, I will be the first to admit it is a necessary one, and one that has to be made by Convocation. So, Mr. Wright.
Thank you, Treasurer. The request that we make the decision today amounts to a request that we trust the judgment of the task force because they've studied and consulted on the issue for so long. And normally we do that. But Convocation on this important issue has had only 10 days to think about the ultimate recommendation. And we will have had only a few hours, and we haven't even started, to hear, and more importantly, consider the observations and arguments that would be put forward later today. I agree with those who support that we should commence the debate today, but leave the decision for another day. Now, back in 1995, when I was first elected as an 18-year-old, and the years after that, we would hold committees of the whole, not on every issue, of course, but only on critically important issues, which this is. And the Committee of the Whole gave Convocation a chance to thoroughly debate what the committee had recommended, and the decision was then taken at a subsequent convocation. And as I said, we did some of our very best work in that environment. And the motion as amended today will give us the benefit of that kind of process. And as a matter of governance, I think Convocation should, going forward, think about having committees of the whole on anything that has the kind of profound ramifications as this issue does. And Treasurer, I support your notion that we only need to defer it by about 40 days to late November, but you also have the luxury of, I think it's the second Friday in December. We are required to hold that day open in case we need it, and if we need it, we would have this thing wrapped up in 2012. I support the amended motion. Thank you.
Thank you, Mr. Wright. Ms. Rothstein?
Thank you, Treasurer. I rise to support a motion to adjourn our decision, and frankly, I would say debate, but I'll clarify that. Not because I favor one position or the other on the merits of the dispute. In fact, I urge all of you who support the majority position or the minority position, or like me are struggling with the decision that you might reach. I don't know, I must have a t-shirt on because everybody's writing me and phoning me because I am aggressively undecided. I am aggressively undecided. I see so much merit in the views that have been put forward by the majority. I know how hard they've worked. I accept that the consultation has been extensive. But equally, I am troubled by some of the points made in the minority report. And in the 10 days that I've had to finally read all 100 pages, I found myself as torn as I've ever been by any decision in this room, much more so than anything I can think of in a long time. And I have benefited greatly, not from the positional statements of the various legal organizations that can be seen to be, putting forward views that they've strongly taken already and attempting to protect positions that they've taken, but by so many individual members of our profession who have written and said, wow, this is really important, and we want to participate in the debate. They're not asking for further consultation. It's not a fault of what has gone on so far. It's not even a mea culpa is necessary because it's only been 10 days. Everyone did the best they could. But I don't actually share Mr. Faulkner's view that there are people out there who weren't paying enough attention. People were paying attention. But until they read the rich, textured decision of 100 pages from this committee, how could they possibly grapple fully with the issues? I haven't, and I can't. I am concerned about starting the debate, folks, because I worry that in this very fraught environment that our positions will get entrenched too quickly. And I have seen in just the last 10 days some will in this room to try and bridge some of the differences between the majority and the minority. No, it won't ultimately get consensus in this room, I accept that. And maybe we'll never have a unanimous report. But it's something that we have to try. It's something that we have to do. We have to make the decision we're about to take as good as we possibly can. And I believe for another month, for the sake of the month, we must do that. So I urge everybody, wherever you're coming from, to support an adjournment. I would argue, Treasurer, that the way we should do it is to have each side of the debate tabled by their presenters, but we should avoid discussion on the issue. That'll probably take us till the end of the day, I expect. It will certainly help inform the profession about what we think and why we think it, and what the strengths and weaknesses of each position are. But I would urge the jury of this room not to begin our deliberations until we've heard from everyone who wants to be heard, and there are so very many of them.
So you are speaking against the motion?
Well, I don't want to speak against the motion, make it more complicated. I'm just sort of suggesting, and maybe Mr. Faulkner could accept that this would be one way we would do it, is that we would have each report, the minority and the majority presented, strengths and weaknesses discussed by their presenters, but Convocation itself, the people in this room, wouldn't actually have to begin the decision makers. I don't want to make things more complicated. If I have to, I will support the amended motion. I don't want to ask for a withdrawal.
Thank you for not making things more complicated.
But I urge everyone to leave us time to perfect what's before us.
Well,
next referendum.
Your suggestion is noted. We should probably at some point, we will at some point deal with this motion, and then if it succeeds, we can perhaps deal with what this will look like. But let's... Sorry? I would like to take this vote, if we can, before the break. So I'm going to urge people to try and be as succinct as you can be, and if you can, not repeat points that have been made already. That would be appreciated. We have a minute. Mr. Sandler.
I'm going to be very brief. When one heard Ms. Murchie's comments, I was really impressed with her advocacy and thought she could be right. And I heard Mr. Wardle, very impressed with his advocacy and thought he could be right. had the same reaction about Mr. McDowell and disagreed respectfully with Mr. Falconer. I'll explain why. Ms. Rothstein has alluded to it, but if the view of the room is that the decision should be deferred, with all due respect, the debate should be deferred. And the reason I say that is because if the message that we are trying to send to the profession, whichever way your view is, whether it should go ahead or not today, but if the view that you're trying to communicate to the profession is we recognize that the consultative process is different than having a report in hand and responding to a report in hand, then the idea that we would express our views today and then receive the additional input from the profession is the exact kind of procedural quagmire that causes more problems than it solves. Because the message is that we're prepared to take positions, articulate them publicly, and then be invited to recant or modify or change our views. That isn't the way we run trials. It isn't the way courts hear submissions. In my respectful view, the better course is to say that if the public interest is such that the decision should be deferred, then the best way to deal with it in a way that meets the needs of all involved is to say, let's hear from the authors of the majority-minority reports today so that the profession can hear those views fully articulated, and then let's hear the input from the profession that follows from that, and then we'll have an informed debate when we come back in November. And what was lacking for me, and I was undecided on whether I would support a motion to defer or not until I heard the argument here, but what decided it for me is I heard no argument on the part of those who suggest we should decide today as to the prejudice. For me, isn't that the operative factor? If you've got a large segment of the profession that are saying, for whatever reason, we don't feel we've been heard, we don't feel we've had an opportunity to be heard, and we've only received the materials, as Mr. McDowell said, in a way that some mea culpa may associate, not with the consultative process, which was strong, but with how recent the report was released. And there's no prejudice. For me, it's an easy call. And the only difficulty for me now is whether or not I'm comfortable starting to articulate my position. And when I articulate positions, to be frank, I articulate them in fairly strong language, as you know. And I'm not comfortable articulating my position on the issues until I've heard from the people that we're inviting to hear from. So it doesn't make sense to me. So I don't want to complicate, to parrot what Ms. Rothstein said, I don't want to complicate the issues further, Treasurer, but it seems to me that if people are of the view that we ought to welcome input from the profession at this point, and that it will make not only for a better decision, but more importantly, make people feel that they've been heard and ultimately increase their willingness to buy into the decision that we ultimately make, because they have been heard, then why would we start expressing our views in strongly held language at this point rather than allow that process to take place? And I should say that the division here is not along the lines of majority versus minority, because, as some people know, I've tentatively expressed a view about this. Has nothing to do with the expression of my view. It has to do with process, as far as I'm concerned.
My thinking at the moment is that we might want to take our morning break, and we might be able to have among the various sponsors of the motions and the amendments, we might be able to give them some time to discuss how they might reformulate the motion if that's what they want to do, and then we can come back and try to finish up the debate.
As a point of order.
Point of order, yes.
How many more people do we have on the list?
At the moment, we have 1, 2, 3, 4, looks like about 5, half a dozen.
Thank you.
All right, so I see some nodding of approval of that approach in Convocation, so we'll take our morning break, and we'll come back in about 15 to 20 minutes. Thank you.